Hello, and welcome to Legal Acquainted, the channel that's here to guide you through the legal labyrinth that makes absolutely no sense, but somehow dictates large portions of our lives. Did you know that nearly 20% of small businesses face bankruptcy within their first year? It's basically the business equivalent of a hamster escaping its cage, statistically likely, and usually very messy. But before you start shoving important documents behind the refrigerator and booking a one-way ticket to the Cayman Islands, let's take a deep breath and unpack this. Today, we're going to break down exactly what you need to do if your business is considering filing for bankruptcy. And trust me, it's probably not as scary as a toddler with a tuba. Probably. Okay, so first things first. Before you even think about uttering the B word to a lawyer, we need to talk about your assets. And by your assets, I mean things you probably don't want a bankruptcy court treating like they're up for grabs at a particularly aggressive yard sale. Think of your business as, well, a business. A separate entity from you, the person. Like that friend you have who still wears Crocs in public. You might be associated, but you are not legally responsible for their fashion crimes. Reinforcing this corporate veil, as it's called, is crucial. It means making sure your personal and business finances are properly separated. No dipping into the company account to buy a new hot tub. Now, I know what you're thinking. John, should I start transferring everything I own to my grandmother who still thinks Beanie Babies are a solid investment? Whoa there, cowboy. That's called fraudulent conveyance, and it's about as subtle as a mariachi band at a library. The court can and will reverse any transfers made to dodge creditors. However, there are perfectly legal ways to protect assets pre-bankruptcy. Talk to a lawyer about strategies that apply to your situation. Now, let's talk about everyone's favorite topic, bankruptcy chapters. It's as exciting as choosing which tax form to fill out, except with potentially higher stakes and fewer tiers of existential dread. Most people have heard of Chapter 7, which is liquidation. It's the business equivalent of hitting the reset button. Then there's Chapter 11, which is reorganization. Think of it like a really intense makeover show for your business. But hold on, folks, because there are other options. Chapter 13, for example, is specifically designed for sole proprietorships and can help you restructure your debts and keep your business alive. And then there's Subchapter 5, which is like Chapter 11's cooler, more efficient younger sibling, designed specifically for small businesses. Choosing the right chapter is crucial, and it depends on a variety of factors, like the size of your business, the type of debt you have, and whether you want to try and keep the business going, or just want to hit the eject button and run screaming into the sunset. Here's the thing about creditors. They actually don't want you to file for bankruptcy. I know, shocking, right? It's like discovering your cat secretly loves you, or that politicians sometimes... Okay, bad examples. The point is, creditors would much rather get some of their money back than risk getting nothing at all. That's where a workout agreement comes in. It's like couples therapy, but for your business, and the people it owes money to. You can negotiate with your creditors to restructure your debt, extend payment terms, or even settle for a lower amount. Think of it as a pre-bankruptcy intervention. And don't be afraid to signal distress early on. Creditors would rather work with you than be blindsided by a bankruptcy filing. Now, let's talk about the automatic stay. Imagine it as a magical force field that surrounds your business the moment you file for bankruptcy. It stops all debt collection activities dead in their tracks. No more harassing phone calls. No more threatening letters. No more debt collectors showing up at your door dressed like they're going to a Star Wars convention. However, and this is a big however, the automatic stay isn't completely foolproof. There are some exceptions. For example, the IRS might still come knocking if you owe back taxes. And certain secured creditors, like those who hold mortgages or liens on your property, might still be able to proceed with foreclosure or repossession. It's like finding out your shark-proof cage is actually made of chicken wire. You're mostly protected, but there are still some very real dangers lurking out there. The bankruptcy trustee. Not your friend, not your enemy, but definitely someone to be wary of. Let's talk about the bankruptcy trustee, shall we? This is the person appointed by the court to oversee your case, and they have a very important job to represent the interests of your creditors. That's right, folks. The trustee isn't there to hold your hand and tell you everything is going to be all right. They're more like a referee in a boxing match. They want to make sure everyone is playing by the rules, and they're not afraid to throw a flag if they see something fishy. So, how do you work with a trustee without accidentally getting a metaphorical black eye? Be transparent, be organized, and be cooperative. Provide them with all the information they need, answer their questions honestly, and don't try to hide anything. Bankruptcy's hidden costs. Because life is full of unpleasant surprises, like finding raisins in your cookie, filing for bankruptcy isn't free. In fact, it can be surprisingly expensive. There are court fees, attorney fees, and even the possibility of having to pay back some debts in full, like those pesky student loans or child support payments. And then there are the hidden costs, the things that nobody tells you about until it's too late, like preferential payments, which is a fancy way of saying that the court can claw back any payments you made to certain creditors in the 90 days before filing for bankruptcy. It's like finding out that the all-inclusive resort you booked actually charges extra for using the toilet paper. Beyond bankruptcy. Because sometimes there's a trapdoor under the trapdoor. Okay, so we've talked about the different chapters of bankruptcy, the role of the trustee, and the hidden costs you need to be aware of. But what if bankruptcy isn't the right option for you? Believe it or not, there are alternatives. One option is receivership, which is kind of like handing over the keys to your business to a neutral third party who will try to sell its assets for the highest possible price. Another option is an assignment for the benefit of creditors, or ABC. This is similar to bankruptcy, but typically faster, cheaper, and less complex. It's like choosing between getting a root canal or having a tooth pulled. Both options are pretty terrible, but one might be slightly less painful than the other. Outro bankruptcy. Not the end. Just a really weird plot twist. Look, I get it. Bankruptcy can feel like the end of the world. But it's important to remember that it's not a personal failing. It's a legal process. And like all legal processes, it's confusing, frustrating, and often feels like it was designed by a committee of pigeons. But it's also an opportunity for a fresh start. A chance to reorganize your finances, learn from your mistakes, and come out stronger on the other side. Remember, bankruptcy isn't the end. It's a new beginning. With the right steps, you can navigate this challenging time and come out stronger. If you found this video helpful, please like, share, and subscribe to Legal Acquainted for more legal insights. And remember, if you're ever feeling lost in the legal wilderness, just remember, you're not alone. And also, maybe consult an actual lawyer.